So we'll move forward with our eighth session. This session will focus on, let me just see, antitrust and competition litigation fueling third-party funding. And the moderator for this session is Daria Shirokova, and she will introduce the speakers to you guys. All right, so Daria, we can take over from here.
Hello
Thanks.
again. So I'm not specialized in third-party funding, but it's the most pleasant part of the day for me, being a moderator, learning new things, and just introducing people. First speaker is Christopher Rotter. Christopher is a managing partner of Hausfeld Berlin, who is one of the pioneers of private enforcement in Germany and Europe, and he was involved in a lot of antitrust cases. Then Mark Keane, who is a director, I remember your name, Mark, director of litigation funding at Harbor Litigation Funding Company, who is one of the oldest funders in the market, and Zachary Krug. He's an American lawyer and now senior investment officer with Woodsford Litigation Funding. So we decided that it's better if you do this session more interactive, because it's very weird spot after coffee but before the lunch. So in order to organize this interactive session, we would like to know what is your knowledge about the third-party funding in general. Can people who know what it is and know what are the basics of that raise their hands? So we have prepared audience. We will still touch upon the basics, but then our panel will go more in details on competition cases. Thank you. Now we will start our session.
Thank you very much, Daria, for this kind introduction. I just looking from the perspective of my firm, we're active in the US, in the UK, and in civil law jurisdictions, mainly in Germany, where I'm the managing partner with offices in Berlin and Düsseldorf. And the interesting thing about competition litigation is that you are dealing with usually with global cartels. So if you have cartel infringements, nowadays they are not focused on local or regional markets, but if you cartelize products or services, that has impacts on many markets beyond just the European Union or the United States. And then it's very interesting to see which tools do you have in these various jurisdictions that can be used in order to enforce claims of cartel victims. And in the United States, such cartel violations usually qualify for class actions. So our firm would be the one then to file class actions here in the US and here in the UK. In principle, you have, when it comes to competition, something similar like a class action, but I understand that the only case, or the two cases where it has been used, one in mobility scooters, which was a vertical case, one in MasterCard Visa on behalf of 50 million claimants. Didn't work out quite well, so that's why here in the UK, if you pursue claims in cartel cases, you usually do that on the basis of conventional group action, group litigation. In Germany, we neither have class actions nor group actions, so it's a bit more tricky to organize that. What usually you do if you have many claimants is to work with assignment models, where claimants assign their claim to a specialized legal service provider, and that legal service provider then pursues the claims assigned to it. Now, in all three scenarios, i.e. class actions in the US, group actions in London, and either individual actions or assignment model actions in Germany, we make use of third-party funding. And so I think both Mark and Zachary are best placed to explain the concept behind it, and then we could discuss how it actually played out. That competition litigation, I would say, is fueled by third-party funding and vice versa. So meaning I think the rise of third-party funding here in the market in London, but also in civil law jurisdictions, was really based on competition litigation cases.
Yeah, I think it's a bit of a chicken and egg scenario, in that the title for this session is third-party funding competition and antitrust litigation. Equally, I'd say actually it could be the other way around, that actually that's fueling the third-party funding movement into that sector. I know Daria asked at the very beginning, who's familiar with the basics of funding? I'm going to ask a bit of a different question. Who's worked with a funder before? Show of hands. So I think that where we were just kind of start was saying in a nutshell, just for those who may not have worked with them before, funders are basically the kind of, the bottom nutshell, as you say, but it's a funding of legal costs for a claim, and if the claim succeeds, then the funder takes a share of the proceeds. If the claim fails, then the funder takes the risk. I always think that's something that claimants, when they're seeking funding, they often forget, is that a lot of critics of funders can say, well, yeah, how can you be taking a share of the claimant's proceeds? That's their claim. And it's because we are taking the hit. If the claim does not succeed, then not only the claimant's legal costs, but sometimes the adverse costs from the other side, that's a liability that the funder takes, not the claimant. So there's a huge attraction historically for the insolvent claimants in thinking, well, I've got no money, how am I actually going, or I've not got enough to afford a costly set of proceedings, how am I actually going to go about getting my claim heard and getting justice? But then what I've seen, and I'm sure Zach would agree, is that in the past 10, 15 years, you've seen corporates, CFOs, GCs becoming much more savvy about using funding as well, and thinking, well, hold on, it's not just about if I haven't got the money, it's about if I don't want to spend the money. I've spoken to many CFOs who will say, well, I've got a set legal budget for that I'm awarded by our board of directors, and that's all I get to spend. So do I want to use that for growing our business, for doing the transactional side of what we do in the in-house legal team? Or do I want to actually use a lot of it to pay for some costly piece of litigation or arbitration, which firstly I don't even know if it's going to win. I can get a guess of what the merits are, but I don't know if it's actually ultimately going to succeed. But secondly, also, that's going to be a huge drain on our balance sheet. It's going to be a drain on our resources. And it's going to be pressure in terms of going back to the board and giving them updates and having to tell them how much we're spending at every step of the way. So that's where the kind of new, I think, interest in funding and what it can provide has started to create.
Yeah, no, I would definitely agree with that, and I think it certainly has shifted from the sort of classic impecunious plaintiff to being used more broadly by corporates, as Mark said, but also law firms themselves. Particularly in the U.S., we're seeing a lot of growth in what we call portfolio transactions, where we essentially are funding law firms on a variety of cases that they have and taking some portion of their contingent interest. And that, that allows law firms really to manage their own risk, but to grow, to take on new cases. If you're a small boutique or a entrepreneurial law firm that wants to do cases on some form of risk sharing, good cases walk through the door, you take those cases, but then at a certain point you have enough risk on your books and you're turning away cases. Funding can be a way to sort of bridge that gap, both to manage cash flows, to allow you to take on new employees to run those cases, but also to actually take those cases themselves, and really can be a way to bring in business to the law firm. And then the other area we're seeing growth, and I think this one is particularly interesting, is in what we call monetizations, and that's essentially where a claimant or a plaintiff has received a rendered award or a judgment, and that's going to be subject to appeal or enforcement, and they can actually take that award and de-risk it in various ways, because the appeal or the enforcement usually isn't that expensive, although obviously enforcement can get expensive of an award. But the real risk there is that you're not going to be able to enforce it, or that it might be reversed on appeal. So you can actually take some portion of that money off the table right now and get on to the business of what you're doing. So those are sort of, broadly speaking, some of the ways in which funding is being used. I think it might be worthwhile just to sort of talk a little bit about the nuts and bolts, and then we can get back into competition law. And I think one of the questions or one of the themes that probably will run throughout our discussion here is, to what extent is funding fueling cases and bringing more cases to the fore, or is it the opposite? And I mean, from my perspective, one of the things I do think it's important to think about is that when we're looking at cases as a funder, I mean, we're really looking at funding the most meritorious cases we find, and there are many cases that I think are decent cases that I would feel pretty good about as a lawyer if I was a litigant, and we won't fund those cases for various reasons, because it's just not clear enough, or there's counterparty risk or enforcement risk, and so we're really looking for the best cases. And so I think the notion that some critics of the funding industry or some people have concerns about whether the inflow of capital is going to lead to a sort of an outflow of new cases, and the fear would be on meritorious cases. And so from my perspective, the answer is no. And then there's a different question, which is, does it lead to more litigation? And here, I think that question is still a little bit uncertain. But I think we do have to question this notion that more litigation is necessarily a bad thing. I mean, from my perspective, if we're bringing meritorious cases, whether they be investor-state arbitration or a competition claim that has merit, that's a good thing. So that's sort of, I think, something to think about. Should we talk a little bit about sort of how it works?
Actually, yes. Actually, the other question, listen to Zachary. It's very interesting. How do third-party funders decide to fund a claim? So how the claim should be, what should we do, how to apply?
Sure, and I think maybe Mark and I can talk briefly, but I'd also be interested to know your experience in terms of when you actually have a sort of arrangement, a more longer term arrangement with a law firm, as opposed to a sort of case by case. Because typically with case by case, a law firm will come to us with a specific case, say it's an antitrust case, and they will say, here's the claim, here is the theory of the case, here's our economic models, and we will take a relatively quick look at that, and then try to come to agreement on economic terms fairly quickly. And then once that's done, we have a sort of period of 30 days or so of exclusivity where we really dig into the case. And then at the end of that process, we put together a funding agreement and start funding on a sort of on a go-forward basis. That's sort of the, in brief, how it works.
Nice.
What is the no for funding? In which case you will say, no, I cannot fund this claim? If you have an example.
I would say there are many cases.
Yes, many cases without details. Just I know that you cannot disclose the privileged information, but still, just to show people who are not that much in competition law to understand in which case you won't use, you won't fund.
It's probably more fun to give some examples.
Yes,
that
examples are always
so-
good, actually,
yeah,
right?
clear no. So the other day we had a call from a client who had an arbitration award that they needed to enforce in India. And I said to them, okay, great, so can you tell me a bit more about it? They've been trying to enforce it in India for the past 13 years. And I thought to myself, well, I said on the phone, so why have you not succeeded if it's been 13 years? And I said, well, there's been various court applications and everything, and then there's issues about the defendant's assets. And I said to the lawyer, I said, would you fund this if you were a funder? And he said, probably not. I was like, well, why would we? I didn't say it that cruelly, but that's the kind of things that go in your head. So, I mean, I always think it's like the most easiest way of saying it is saying, particularly when all the claims that we do look at usually come through law firms, is you say to the lawyers, do you like this claim? And, if they like it, chances are we are going to as well.
Yeah, I mean, I will say, you get a lot of, obviously, we say no to a lot of cases that are clearly problematic cases where I just was looking at a case that on the legal merits actually is decent, but the counterparty that we'd be dealing with has been convicted of fraud and embezzlement and bribery in a federal court. And so that's a problem for us, even though the legal merits of the underlying claim are decent. Bringing it back to competition, we see we're increasingly in the U.S. seeing a number of cases that are, I would say, creative attempts to use the Sherman Act and private enforcement of the antitrust laws, in a way that has some merit, but there is a sort of a disjuncture between perhaps the law and the market. And I'm thinking particularly in terms of we see a lot of cases against some of the, sort of big technology companies. And so, I repeatedly see cases against things like Uber and other players who have obviously impacted the market in a significant way, but whether it's an antitrust violation that a taxi medallion company can assert, I think is a much harder question, and generally the law has been disfavorable to those kinds of arguments. But we see a lot of those sort of creative uses. But I will say, like I said, even the cases that are relatively decent, we tend to be.
Would you fund a case against the state, for example, under the Sherman Act?
Well, a large portion of our cases are against sovereigns in various ways.
So it also depends on the sovereign, as I understand. If it's a risky country, you won't do it.
Yeah, but coming back to your point, I would say both from a client's and a law firm's perspective, it makes obviously more sense to go for a portfolio deal. The reason for which is if you have to go through the trouble of making a full investment proposal, on a case-by-case basis, that is obviously very burdensome for the client, for the law firm, and for the funder. And let's put it that way, due to the different bar rules and different legal regimes in civil litigation, there are obviously very different business models. So in the United States, lawyers can work on a contingency fee basis, right? And on the other hand, you have class actions, i.e., where effectively there are no clients involved. So the 2 or 3, if you will, nominated plaintiffs of the class, they never appear anywhere. As a law firm, you don't have any contact to so it is effectively the law firms who bring the case and who pursue the case. And the way it works is that you have the risk of losing the hours which you have spent on the case. So that is called the lodestar. Yeah, and by the end of the proceedings, the court will look at the hours you've spent on the case and on the costs and other payments you made, usually to expert witnesses. Yeah, and then says, okay, if that's appropriate, then you get awarded with the reimbursement of these costs and your hours, and you get a multiple on that. Now, in the good times of class action litigation, which is some 15 years ago or so, you got a multiple between 7 and 8, yeah, on the hours which you have actually spent. I think in the last 5 years, the average was between 1.5 and 2, so not really worth a while. I mean, if you look at, you have to invest, yeah, your time, and you have to actually pay all these costs yourself. And sometimes it takes you, up to 8 or 10 years before you get your money back. And so effectively, third-party funding in the US is funding the law firm, yeah? So it's an arrangement between the funder and the law firm, where the funder says, okay, I am investing in your cases, I pay, you know, your costs, and at least some of the billable hours that you have, and so there the third-party funder actually works more like a bank, yeah, so to speak, and they then effectively even take a share in the law firm's business, yeah, and then take over the entire portfolio. Now here in Europe, I would say it's a very different concept. One reason is what you don't have in the US, but what you have here is adverse cost risk. Now, mind you, in the US, you can bring an action which doesn't have any merits, right? From our, you know, with our standards, because, you know, if you look at the Twombly standards that you have to meet in the US for a claim to be admissible, I mean, that is completely ridiculous if you compare that with civil law standards, yeah, that you have to comply with. Now, anyway, if then eventually your claim is dismissed, then each party has to bear its own costs. That is, by the way, the reason why most of these class action litigation end up with a settlement, because there's a simple mess behind it, yeah? So as a defendant, you know, okay, I can litigate for a couple of years, win the case, have the case dismissed, but until then I've paid what? 10 million to my lawyers, and the money is gone, right?
I have a question about the billable hours. Do you control the billable hours? Because some law firms, they tend to inflate it, or
Well,
it's from my personal experience.
well, I mean, look, I've been on the client side some 20 years of my career, and in some cases I share your impression. But let's put it on the other way. It is you can always argue whether it is at the time was effectively used. Yeah.
So you do look in the time, because they have these special sheets, right?
Absolutely, and this is the experience that I've made as a client. I always looked up the time entries, yeah, and when there were reasons to complain, I did complain, and the same happens, you know, now. Before I send out an invoice to the client, I really look at the time entries and see whether it's appropriate or not. So this is obviously something which also the courts do in the US. So
Absolutely.
Eventually, it is not that the court always accepts 100% of the time entries of the firms. That's
What should the law firms submit to you in order for you to take a decision? Do you treat differently law firms you work on a regular basis from new law firm? Is there a set of documents they should submit, especially in competition?
well, let's again, as I've said, you have to look at the different business models in the US and in Europe. Yeah, in Europe, before you bring a claim, you always have to keep in mind that if you lose, it's not only that the money you have invested, is gone, but that you have to pay the court fees and you have to pay the defendant's lawyers, and especially here in the UK, this can be a lot of money. That is why part of the package that third-party funders, if it's about litigation in the UK, offers is to pay the premium for so-called after the event insurers, because by the end of the day you got to pay when you lose, right? And that is a lot of money for the client. It's a lot of money for the law firm. It is even a lot of money for the funder. So the funder says, well, maybe it's more useful that I pay the premium, for the insurer to make sure that I'm covered there. But you see, against that background, you need to have quite a strong case before, as a funder, you would say, I'm paying for it. And now comes the good thing about competition litigation. Here in Europe, it is, I would say, more than 95% of the cases are follow-on cases. Follow-on cases means there is a decision by the European Commission or a national competition authority which finds that or which establishes the fact that there was a cartel. This decision is binding for the courts, and there is even a legal assumption in the directive implemented in the member states that the legal assumption is if there is price fixing, then prices are inflated. So that basically means it is established that you have a claim. The only question is how high is it, And that's why follow-on competition litigation cases are relatively attractive for funders in comparison to other cases.
So funders prefer competition cases over arbitration cases, for instance?
I don't think it's that linear. I think that funders will look at most cases, of various sectors, industries, natures of claim. I think that we had obviously said at the beginning it's going to be an interactive session. If there are any kind of questions, I think, that people have in particular, then we can happily do those. We've got some other questions that we thought people might want to ask, but happy to be led by people.
We're both Irish lawyers, so we don't have the concept of litigation funding in our jurisdiction. As a lawyer, you have fiduciary duties to your client. As a funder, I'm sure you have a vested interest in how litigation plays out. Would you be able to give some insight in terms of the tensions that might be in those situations?
Sorry, in terms of the tensions?
Yeah, so if you're a lawyer, you need to be responsible to your client,
Yes,
but you have a funding committee.
Firstly, I will say that we at Harbour have been trying to get Ireland to change their stamp duty law for a long time, and we actually took a case to the Supreme Court very recently where, annoyingly, the Supreme Court judges felt their hands were tied and said, look, we realise that this is actually quite outdated and it needs to change, but we're the judiciary, not the legislature, so this has to go back. So hopefully that will be taken on board, because it would be great to see that open up a whole new market. In terms of the tensions that you can always see, there is always going to be a tripartite relationship. You've got claimants, you've got legal team, and then you've got funder. The first thing I would always say is that the legal team's client is always going to be the claimant. And that's, again, going into these principles of champion management. We are there just to pay, to pay the money. We're entitled to monitor how our funding is being used, and I think there has to be a dialogue. But ultimately, certainly the way we structure, and I'm sure you'll say the same, is that ultimate discretion and control has to always lie with the claimant. So, notwithstanding that we may have an opinion, then ultimately, your duties are always going to be to your client, and we have to accept that's another risk and part of the funding that we provide. I think one of the things that we particularly do when Harbour looks at funding a claim is ensuring that we can trust the legal team and we know they're the right guys for the job, because that usually mitigates the risk of a strategy that we might be concerned about coming about, or having to control an unwieldy claimant who can be a bit unpredictable. But the other thing I would say is ultimately, the claimant and funder actually have a key common objective, and that's to get the best possible outcome for their claims. So, we have found a lot in many cases that we funded that claimants actually quite like having our experience and expertise, not as something to fetter, but somebody to just bounce ideas off, and also just kind of gauge, kind of our views on a particular course of action. If we're asked, we're happy to give our thoughts.
Could I just ask, sorry, I'm a colleague of Kevin's, you mentioned the persona decision. We're actually acting for a number of plaintiffs in related champerty decisions, or champerty cases, which are before the Supreme Court at the moment, and we're actually waiting judgment on those, the SPVosis case. But just in respect of the persona decision, one of the Supreme Court judges said, obiter, that there may be other ways around it. While third-party funding per se is prohibited in Ireland, there may be other methods or mechanisms in which you could actually invest, such as taking a shareholding in the company, or by doing this by way of loan, etc. And I just wonder, perhaps Ireland may be regarded as a small market, and you don't give a huge amount of focus to it, but I'm just wondering, have any thoughts been given to utilising some of those other mechanisms that the Supreme Court have suggested?
Absolutely, and I think that's at the moment it isn't over to comment, but there is a hint that actually, if somebody is willing to actually try an alternative structure, as you say, by SPV or shareholding or something, it still is going to have to be tested by the court, and you can bet your bottom dollar that the defendant is still going to be raising principles of Champerty maintenance, saying, well, this is still isn't allowed. But there are potential ways where actually something could come through. But I think ultimately what's really required is for the government actually to review their policy and law on this, and actually to step in and actually assist the judiciary. Certainly, I don't think that Ireland is a small market, given that most of the big blue chips are now moving over there.
Well, I know I'm just conscious that we're the only two Irishmen on the floor, and I don't want to be taking up too much time.
No, but I think you raise a very, very fair point. Now, if you look at competition litigation in the sense of follow-on claims, following European Commission's decisions, I would say in the past, the dominant venue was London, So the European Commission's decisions were binding for courts in England. The jurisdiction of the Court of Justice of the European Union was binding for English courts. And let's put it that way, English judges were quite creative when it came to find an anchor defendant in cases, to make sure that it is the London bar who makes money and not the German bar or not the Dutch bar. And let's put it that way, with the UK leaving the European Union, things get a bit messy, because if the decisions are not binding for English courts, then I would say one of the main reasons why follow-on litigation is so attractive would fall away. And under these circumstances, why do people go to London to bring their claims? Certainly not because the hourly rates of barristers and Queen's Counsel are so competitive, but the main reason is because it is an English-speaking country. So obviously it makes a lot of sense, for Ireland, you happen to be, you also have Gaelic as an official language, but I understand that the court procedures are in English, and so, you could really position yourself as a forum, not to be the sole forum, but I think now what we see in the future is that predominantly cases will be brought in Germany and in the Netherlands. And the downside for international clients is that our court procedures are in German and Dutch court procedures are in Dutch. And, this is always a bit clumsy, because you have to make translations, and then these translations sound a bit strange, etc. So Ireland would be a good place. we went there last year to many conferences, speaking to the Irish bar, to lawmakers. We were very interested in the Volkswagen case, which was brought in Ireland, in the trucks case. Yeah, so
we're
it was
involved in that.
actually,
Yeah.
my friend Evan O'Dwyer, I can remember when I asked him, because he wrote the Volkswagen case there, and I said, by the way, I haven't been to Ireland yet, but do you also have trucks there? And he said, oh yeah, we do have trucks there, and then he went about it. And so I found it strange, if you have such a business opportunity, yeah, that lawmakers, don't make use of it. But maybe it will come, but really it is something, and I think that funders here in London, would be happy or happier to go to Ireland than, to go to the Czech Republic or so, yeah, to fund cases.
But at the same time, those who are not happy with the European decisions, they may go to London.
Yeah, but the problem it makes a difference. It makes a difference whether a regulator's decision is binding, full stop, or whether you can challenge it. And what will happen in the future is that, of course, you can base your claim, on a regulator's decision from outside the UK. But what will the defendant do? Yeah, he would say, well, look, this is not compatible with whatever English law, and the facts were not thoroughly established, and that's why it will not be attractive. And so what I can see, and probably Mark and Zachary, you're a bit closer to the market, but what I see at the moment is that we will have a shift from follow-on competition litigation cases to securities and more complex commercial litigation cases in London. Or what is your
More antitrust style.
Yeah.
Yeah, so I do think this is not specific to obviously to Brexit, but I know that one of the things we're seeing in the U.S. is a sort of a really clever use of securities laws in ways where or cases that sort of merge securities litigation and antitrust, where there's a securities violation that has market impacts in the way that you have with some of the commodity price exchange litigation, and really those are securities litigation, and I think you're going to continue to see that. I do know it's a little different in the U.S. because obviously in the U.S. most of the litigation that you see in the antitrust arena is actually not follow-on. Here in the U.K., what I've been seeing, I've actually been seeing a lot of follow-on actions or attempts to bring follow-on actions in sort of periphery jurisdictions, whether it's in Spain or somewhere like that, where the argument we're told is that the set of plaintiffs there are just more comfortable doing it in Spain, even though maybe Germany might be a better market. Now, obviously this is something we always press the litigants on, or the lawyers on, is what in particular makes that jurisdiction better than Germany or the Netherlands or somewhere else, and the focus is usually on the low cost of the lawyers, the relative expense or cheapness of ATE insurance, and speed. And then, I do think what will be interesting is whether some states and some sort of judiciaries make an attempt to really sort of develop expertise and sort of promote themselves as a forum, and try to essentially solicit or invite these sort of claims. And you can think of claims as a sort of type of capital inflow or investment, and it's certainly true that different jurisdictions compete to bring those cases, and I think you're starting to see that, and I think you'll probably see it more if indeed the UK falls out of favor.
Yeah, we've been asked. Sorry, I'm just going to raise a hand actually. So, I was going to say quickly before we come to your question, we get asked so many times now, well, what does Brexit mean for funding competition claims? Is this the end of it? And it's like, well, no, but it's just an extra wrinkle. Ultimately, I think where this is going to go post 29th of March next year is that there is still going to be EC decisions that come out which are going to be heavily persuasive to any competition authority or court or tribunal in the UK. It may mean that actually the duration of a competition claim or antitrust claim in the UK is going to take slightly longer. It may mean that there may be a little bit more ambiguity, but I think there's still very many compelling reasons for why funders should be continuing to fund competition claims post-Brexit. Sorry, I've got to your question.
Sorry, but I'd like to bring you back a little bit to the basics. You've made several references to portfolio funding. Could you give us some details about what you mean by portfolio funding? Is it a blanket check for 10 million euros to do what you want? Is it for a certain number of cases? Do the cases need to fulfill certain criteria? Maybe some details would be good.
Sure. I think most people will probably want us to say, yeah, it's a blank check for 10 million euros, but sadly, there's no such thing as a free lunch like that. I think that you need to be careful when you refer to things like portfolio funding, because actually it can mean very many different things depending on who you're speaking to. So, for example, it could be, as Christopher was saying, about a law firm actually doing some portfolio financing with a funder through a number of claims that they're looking to de-risk themselves on because they're on a contingency. On the other hand, it could actually be that it's portfolio funding for a blue chip company who's got a big book of litigation, all different types, and is looking for you to fund those, and it may have different lawyers on them, it may have different jurisdictions, but the commonality is the company, or the claimant, sorry. The other meaning it could have is where you have the same law firm, but they have various different claims that they're not on contingency for, but they're introducing you as a funder to all these various claimants who you then do some kind of arrangement where you can work out budgets across the board of those matters with the law firm. So first thing I would always say is there's more than one meaning of what a portfolio arrangement is. I always like to think it's just, essentially in its finest form, it's just a package deal in that you basically are funding more than one claim at the same time. The things to look for, I think, you need to be careful from a funder's perspective that when people come to you with a number of claims saying, I want funding for all of these, that they haven't just taken all the crap from their litigation book and said, we'll give that to a funder. But actually there is actually some decent things in there because it's all about the risk. So there may be some things which are a bit less risky, not necessarily the watertight, claim that's definitely going to succeed, but going down to the ones which are a bit more difficult. The other thing is about the economics. So again, one of the real kind of areas for package funding to be suited to is where you might have a number of claims that by themselves just don't have a big enough quantum to make the funding economic. But actually, if you group them all together, then you may be able to make something that's a bit more economic to be able to fund.
Yeah, and the other, from a funder's perspective, when we're looking at a portfolio, the whole point is to have diversification. So the more diversity you can have in terms of the different types of cases, the jurisdictions, the quantum at issue, the better from our perspective. And obviously it really depends on the types of cases, but generally we're looking at something like you need a minimum of 5 cases to really be a proper portfolio. And the key thing that makes portfolios attractive is that diversification. It lessens risk from our perspective, and so concomitantly the cost of our capital is less. And so if we are talking about a single case, we're typically wanting a return that's something like our invested capital plus maybe 2 to 3 times that. That might be a typical return, which I see eyebrows raised because it is expensive, but it's risky. It's non-recourse. With a portfolio, our return is cross-collateralized against the portfolio of cases, and therefore our risk is lessened, and the cost that we're going to look for, or the return, is going to be substantially less. It might be something more akin to an interest rate, an expensive interest rate, but something like 30%, which is obviously very different than 300%. So it's a potentially quite attractive if it can be structured right.
Yeah, and I think by the end of the day, it's all about risk management. I mean, if one case goes bust, yeah, and let's face it, I mean, even a good case, even a case with merits, can go bust for whatever reasons. But now, if it goes bust, then you need at least 2 cases that go well to compensate that, yeah. And so I think the whole idea behind a portfolio deal is that you collateralize the risk, meaning to make sure, okay, that by the end of the day, I mean, it's not only the funder who takes part of the risk, but usually it's also the law firms, yeah, who takes some of the risk. And that you know by the end of the day that it's better to manage the risk if you don't bet all your money on just one horse. And from my time as an in-house counsel, what we did there is we've actually built up a portfolio ourselves. We had like 20 cases where we knew, okay, then if you have, once you have 20 cases in parallel, you can take more risky decisions in the sense of taking a case in, which on its own, yeah, you wouldn't have done. But by knowing that you can collateralize that, you can take more risk, and again, it's no venture, no gain, yeah. And so if you bet all your money on one horse, yeah, you won't be very successful. And I think that's true for both claimant law firms and third party funders. So it's the same type of thinking behind it.
Yeah, I think just following on from that, just going a bit broader, I think that there is a tremendous flexibility in what funders can offer. It's not just a stage of, we do single case funding and that's it for that one. There's the portfolio arrangement. That in itself can have a lot of flexibility. And I think one of the things that we at Harbour are most kind of interested in doing now is tailoring packages particularised to a particular claimant. So, or whoever will come to us and say, well, particularly if it's a more larger corporation who's actually looking to this as a hedging tool, then it's more about working out with them, well, what are the kind of things that would help. So, for example, in an insolvency, a huge piece of insolvency litigation, we don't just fund the legal costs of a particular claim. We might be funding the liquidator's expenses as well. We might be funding the corporate overheads of the company itself to just keep, or SPVs owned by the company, just to keep those companies alive because they've got claims. There may be funding that we do just for enforcements of awards or judgments. There may be funding that we provide where we essentially just buy an award, an arbitration award, or we buy a judgment. And that's a huge incentive because a lot of claimants think, well, great, I can actually just monetize that now, rather than thinking I have to go for another 2 years to actually get some money out of this and enforce in various jurisdictions and find assets, etc. So there's a huge range of what things that a funder can provide in terms of tailoring it specifically to what that claimant or law firm is looking for.
As we don't have a lot of time left, probably we can cover one more question. Does anybody have a question? Then I think it's good to go back to the title of our presentation, our session today, and discuss whether, in your opinion, the funding actually is fueling claims, whether the competition claims will die without funding.
I think I'm still very much the other way around, that it's the competition and antitrust claims that are actually fueling third-party funding. If a claim isn't there, then there's no funding that can be given for something. I mean, yes, because of the existence of funding, I think it's making lawyers and claimants a bit more savvy about thinking about something that they may not necessarily have pursued previously. But exactly as you said at the very beginning, Zach, it's about ensuring that a meritorious claim is still pursued. So, we're not there to be able to just clog and fetter various courts or jurisdictions. It's there actually about, to be, providing a service that allows something to be pursued that may not otherwise have been done.
Yeah, and I think, at least my experience here, is that it's really the claims are fueling funding. And I think in particular, because I think people have seen, and by people I mean, I don't necessarily mean funders, but maybe ad hoc funders or private equity or other sources of capital have seen follow-on actions as being relatively attractive, and given that the liability is, liability is established, that they see it as almost more of an economic decision than a legal decision. And I see this sometimes with the cases that we get pitched where, a group has built a book of, however many claimants, but they are thinking about it in a really economic way, which is that, here's our book, but if we just put in, X amount more dollars, we can, get 3 or 4 times more claimants. And I mean, in our experience, that doesn't work often, and it can be difficult to sort of to do that. And I think, what you're seeing to a certain extent is that's the logic. It's a more logic that's sort of traditional to markets, where if you like a deal, you can usually allocate more money to it. In the U.S., I think it's a little bit different. I actually think there's going to be more antitrust litigation, and I think what's fueling that is less third-party funding, but more that firms that do contingency and plaintiff work are allocating more of their sort of contingency risk towards antitrust cases. And I think that's partly because there's, I would say, a little bit of a downturn in securities litigation and in patent litigation as well, which are traditional areas where contingency firms, like my former firm, Quinn Emanuel, does a lot of all those things, and I think firms like that will and are just sort of allocating more of their sort of risk appetite towards antitrust cases, and partly that's going to be with the use of funding, but I think it's just the firms see these cases as attractive.
Well, if there are no additional questions, I think we can all go to lunch and meet after the lunch.
Thank you, Daria.
Thank you.
Thank you, Daria, Mark, Chris, and Zach. Well, I would request now Daria to present the memento to all the speakers for their valuable contribution to this panel discussion.
So that's another pleasant moment today.
Is that me? Okay, thank you.
Oh, I'm sorry, there's a name. There's a name.
No, there's no name.
No? There's
No name? Okay.
I
I just wanted to be sure that I don't take Mark's
Because I
mistakes.
didn't find my name
So
either.
that's good.
Thank you very much. Thank you.
First one?
Anyway.
Because I already have mine.
Something to carry.
Thank you. Thank you for a wonderful session.
Thank you.
Thank you so much.